morning, Malaysia. This is Matthias Chang once again from Future Fast Forward. As you realize, I don't often give video addresses one day after another, but rather once a week. But following yesterday's address, when I exposed the hypocrisy and the wayang kulit and diversion of the real issues of what MDB, it's clear that very few, if they have humility and they've taken the trouble to study what I exposed under Section 214, 249 to 255 of the Financial Services Act 213, they will have realized that that was a nuclear weapon for the opposition to battle BN, UMNO and the cabal. If they were sincere, it would have gone viral throughout the country. But the very fact that all the MPs across the political divide were stuck in horror for the exposure shows that what they are. Very few of them are sincere. But never mind, I will now address to the entire Malaysian people what are the consequences of what I said yesterday and explain to you how offenses have been committed by 1MDB, how offenses have been committed by everyone, the board of directors, management, and Najib have been committed under the Act and deemed to have been committed. If we use our grey cells, our otak, we will realize straight away a dramatic implication of what I said yesterday. But for those who still don't understand, I will quickly run over very quickly what I've explained yesterday so that it becomes crystal clear as to the law and the implication. The first is shocking nuclear weapons. And I hope all the MPs in the opposition and the leaders have the guts and the humility to learn and use it to their advantage. Don't pretend, act and pose as YB, Ya Berhormat. You have a duty to the world, to our country, to our people. And I say to all of you, in particular the leaders of the opposition, by my explanation, I'm suggesting that Prime Minister is disqualified to be the Prime Minister, as well as disqualified to be a candidate for the next election, if there's an election, because he has committed crimes for which he has not denied, for which a fine has been paid, and for which the Attorney General has agreed with the Bank Negara that offence has been committed, fine imposed, paid, and no challenge. This is with the consent of the Attorney General. Understand? The Attorney General may not have prosecuted the Prime Minister for 2.6 billion ringgit in his account, converted from 681 million US dollars from Tenor Corporation, second private bank in Singapore, to his bank account in M-Bank. Irrelevant. Because more monies were diverted, wrongly used, laundered via the first US $1 billion loan in 2009, the loans from Goldman Sachs, as Bank Negara has revoked all those transactions and lending in 2009, 2010, 2011. So the donation, even if I concede, is a donation, is irrelevant. The main issue is all the transactions have been revoked by Bank Negara in 2009, 2010 and 2011. So for the illegal, unlawful, and crimes have been committed. Okay? So once again, because yesterday, when I explained to you about offences, I did not reproduce those acts, those sections, for you to photograph. So today, to save time, I will now reproduce every section for you. Please take your handphone, photograph it, and pass it on to your MPs, ADONs, and leaders, and ask them to take action straight away. First, Section 249 of the Financial Services Act 2013. Offences committed by any person acting in official capacity. 2491. Where an offence is committed by a body corporate or unincorporated, a person who is a director, controller, officer, or partner, or was purported to act in any such capacity, or who is concerned in the management of his affairs at the time of the commission of the offence, is deemed to have committed the offence. 1B applies to Najib personally. Okay? He's not a director, controller, officer, or partner of 1MDB, but is concerned with the management of 1MDB because by virtue of the Articles of Association, he has sole authority, and is deemed to commit the offence unless that person gives proof, that the offence was committed without his consent or connivance, and that he has exercised such diligence to prevent the commission of the offence as he ought to have exercised, having regard to the nature of his function in that capacity and to the circumstances. 2. An individual may be prosecuted for an offence under subsection 1, notwithstanding that the body corporate or unincorporated, i.e. 1MDB, has not been convicted of the offence, whether or not prosecution has been initiated or a conviction has been obtained against the body corporate or incorporate. That means, regardless of whether 1MDB is prosecuted or there's a conviction, Najib is deemed to commit offence under Section 249, alright? 1C. Okay? Take a handphone, photograph. Okay. Subsection 4. The penalty of imprisonment for an offence applies to an individual convicted of offence by virtue of subsection 1. Notwithstanding that the imprisonment does not apply to the body corporate or unincorporated by virtue of section 247. Meaning, even if the company 1MDB, a company cannot go to prison, doesn't mean an individual who has committed offence cannot be prosecuted and be in prison. Now this is very important. Handphone ready, please. Offence by employees. Section 250. When a person is liable under this act, Najib, this person refers to Najib. When a person is liable under this act to a penalty for any act, omission, neglect, or default, such person shall be liable to the same penalty for the act, omission, neglect, or default of his employee, director, controller, or agent, if the act, omission, neglect, or default was committed by A. his employee in the course of the employee's employment, his director in carrying out the function of a director, C. his controller in carrying out the function of a controller, D. his agent when acting on his behalf. What it says here is, if an employee in the course of employment, director, controller, agent commits an offence under section 214 of the Act or any other offences, Najib, who's also liable, will be liable for the offences committed by these people. Okay? It seems like, he's vicariously liable. This is very clear. Najib cannot run away. He's equally liable for the offences committed by his employee, his directors, and controller. Because he's not a director of the company, he's not an employee of the company, he's not a controller, But as an advisor here, and by the Article of Association, he has control, sole authority. So he will be liable for the offences of his employee, director, controllers, or agent. Section 250. Section 253, power to compound. I referred to you earlier. Right? Most important, subsection 2. An offer under subsection 1 may be made at any time after the offence has been committed, but before any prosecution for it has been instituted. And above, I've underlined that the governor may, with the consent in writing of the public prosecutor, meaning the Auditor General. Okay? So, an offer to compound can be given by Bank Negara. And subsection 2 going to say, and if the offer specified, the amount of specified offer is not paid within the time specified in the offer, or within such extended period as the government may grant, prosecution for the offence may be instituted at any time other than against the person to whom its offer is made. When offence has been compounded under subsection 1, no prosecution shall be instituted in respect of the offence against the person to whom the offer is compound was made, and any document or thing seized in connection with the offence may be released by the bank subject to such terms and conditions as the bank deem fit. 4. Such sums accepted under subsection 1, the offer of compound, should be paid into the Federal Consolidated Fund. What this means is, if Bank Negara make an offer to one MDB, and one MDB pay the fine, one MDB will not be prosecuted. But in the preceding sections, the individuals can still be prosecuted. Alright? Now you know that Najib has sole authority and will have to give his consent approval for a fine to be paid. Fines may be paid. Offences may be committed, and he is deemed to have committed those offences under those various sections 249, 250, 253. Okay. And even any attempts to commit those offences can be charged. Section 254. Any person who attempts an offence under this act does an act preparatory to or in furtherance of the commission of an offence under this act, or abets or is engaged in a criminal conspiracy to commit, as those terms are defined in the Penal Code, an offence under this act, whether or not the offence is committed in consequence of it, commits an offence and is liable to a penalty for that offence. So, attempt, abatement, and conspiracy. You will recall, I was charged with my client for attempt to sabotage the financial services of Malaysia. 124L Penal Code with SOSMA. Treated like a terrorist. Not only was offence committed, it's also say any act in preparation to commit offence, right, is attempt. So all the schemes put together by Jolo, Najib, Rizal Aziz, and the Arabs were constituted by this definition: attempt, abatement, and a conspiracy. Okay? Because the facts are very clear. Monies were diverted. They set up the whole company on the 18th of September. Loan was given on 25th of September to be paid on 30th September, and the money disappeared. If it was a legitimate transaction, Bank Negara would have revoked the consent approval. And a joint venture signed on 29th of September was revoked and cancelled in March of 2010. That shows the criminality of everything between one MDB and the Saudi Wahhabis. Okay? So, that settles the criminal law. Now, what will shock you now is this. Under the principle of civil law, when you have a company, the company is deemed to have a separate legal person. Alright? Has a separate legal personality, different from the director shareholders, as if a company is a person. And this is the principle by the House of Lords many years ago. 1897, Solomon and Solomon. A company can sue and be sued as if he's an individual. Alright? There's no personal liability of the directors and shareholders if it incurs a debt. The company owes a debt, not the directors, not the shareholders. Because it's what we call a corporate personality. Okay? I will explain the title, Lifting the Veil of Incorporation. The principle is, a company is a separate legal person and can be sued as such. Way back 1897, in the landmark case of Solomon and Solomon and Company, the House of Lords, the highest case, law courts, Supreme Court in England then, House of Lords, effected these enactments and cemented into English law the twin concepts of corporate entity and limited liability. In that case, the apex court simply laid down the company is a distinct legal person entirely different from the members, that is the shareholders, directors of the company. So, if the company incurred a debt, you can't go up to the directors and shareholders unless they provide a guarantor. Separate legal entity. Likewise, in the criminal law, under the Financial Services Act, the company can commit offense, and be charged for the offense, separate from the individuals, the employees, the directors, the controllers. The only thing different is they can't go to the jail. A company can't go to jail. Can be fined, can be charged, okay? But the individuals can be in the criminal offense. Company can be charged for offense. But crooks and fraudsters realize that since a company is a separate entity, it can be used as a cover to shield, to cover their crimes. So many crooks, fraudsters, launderers, money launderers in corporate company, they're not directors. Like Jolo, Najib is not a director. No Form 42 is filed in the ROC. These are the direct shareholders. That's why Jolo says, I'm not even a director shareholder, I'm only an advisor to what MDB. Therefore, I cannot be liable, civil case or criminal case. The law doesn't say that. Generally, the principle is a director shareholder will not be liable criminally or civilly for acts of a company. But if criminal acts are involved, a court will go behind the company, right? And the concept is lifting the veil of incorporation. Okay? Go behind the shell of the company and see who is actually controlling the company. Now, in one MD's case, you have the board of directors, right? You have Casey Tang, Jasmine Lu, Sharil, Arukanda, the whole works. But do they really control the company? No. They answer to one person, the Prime Minister. Okay? So, in summary, crooks and criminals have used this concept to hide their control of the company and escape liability since they are not shareholders or directors of the company. But the law provides that when unlawful acts are committed, such as committing a crime, the court will go behind the company to determine who is in control of the company. This legal intervention by the court is called lifting the veil of incorporation. And so who is the mastermind? That's why Jolo took the money, went around the world, the money, and went to every other company to hide the ill-gotten money, the fraud, the huge loans. Alright? Hidden in other companies. So they say, I didn't have the money. The company has it, not me. But DOJ has now filed an action in court to lift the veil of incorporation and go behind the real people and forfeit the assets. So it's the principle. So when is the veil of incorporation lifted? When will the court intervene? The courts have been more than prepared to pierce the corporate veil when it feels that fraud is or could be perpetrated behind the veil. The courts will not allow the Solomon principle to be used as an engine for fraud. The first case is called Guildford Motor Company Limited against Horn. Mr. Horn was an ex-employee of the Guildford Motor Company, as the employment contract provided that he could not solicit the customers of the company. In order to defeat this, he incorporated a limited company in his wife's name and then took customers from his original company. Okay? The company brought an action against him for stealing his clients. The Court of Appeal was of the view that a company formed by Mr. Horn was a device, a stratagem, in order to mask the effective carrying on of the business of his former boss, Mr. Horn. In this case, it was clear that the main purpose of incorporating the new company was to perpetrate a fraud. Thus, the Court of Appeal regarded it as a mere sham to cloak his wrongdoings. In the other case, Jones against Lippman, a man contracted to sell his land and thereafter changed his mind in order to avoid an order of specific performance. He transferred the property to a company. The court in this case specifically referred to the judgment of Guildford and Horn and held that the company there was a mask in which Mr. Lippman holds before his face an attempt to avoid recognition by the eye of equity. The court awarded specific performance against Mr. Lippman and the company. Under no circumstances will the court allow the abuse of the corporate form. When such abuse occurs, the court will step in. Where will the court step in? To go behind the company to catch the real mastermind. If we can show that the degree of control by the person who's not a director or shareholder, if he controls the running of the company, gives approval, authorization, then must go after that man. His motive for forming a company is irrelevant. If objectively used as a means, a stratagem to commit fraud, or to avoid legal obligations and criminal liability. See, one enemy is wrong. Alright? Not me. I'm only advisor. But he's in control. You see? To avoid responsibility. If you're only advisor, why do you change the Articles of Association to give all authority in your hands? So, the legal principle so far covers the case of 1MDB and Najib. Timing and circumstances relating to the formation of the company. Right? Bear in mind, 1MDB was formerly known as Terengganu Investment Authority. They changed the name, right? And they entered in a joint venture with the Saudis straight away. Okay? Now, there is a Malaysian case, Supreme Court case. Although I've cited to you English law, there's a Supreme Court case of Malaysia. Aspatra, ASPATRA, Sri Berhad, and 20 others versus Bank Bumiputra Malaysia Berhad, BMF case, okay? BMF case. You see, Najib and his advisors, right, challenged to a debate. Salih Krawat, the idiot, numbskull, stupid man, tried to accuse Mahathir as having committed a crime under BMF. And I say in my previous address, I have the 7 volumes of the report, and I challenge that scumbag, the regime, the cabal, to just find one paragraph, one sentence, one word to show criminality by Tun Mahathir. They don't even have those reports, neither have they read it. Because if they have read the reports, the final report sanctioned by BBMB and the 3 members of the committee appointed by the government, Tan Dodin, Ahmad Nordin, former Auditor General, Ramli, partner of Pitt Marwick Mitchell, Chui Ban Sao, lawyer. And they came up with a report very detailed. I was hoping this debate will go on. I hope it will go on. Then we will throw the mess back at those idiots for their false accusations, fake news, and propaganda. This case involved Lorraine Osman, okay? The main culprit in BMF. Okay? So, Lorraine Osman had few companies where the assets were parked. So, the respondents asked the court to lift the veil of incorporation. Alright? And see who actually owned the assets. Is the company a genuine company? And the court held. In this case, Cerita Silberhard against Bank Bumi. Alright? In this case, the corporate veil having been properly lifted and Lorraine Osman having been exposed as the alter ego of Cerita. Alter ego of the company. He was a man behind the scene. He was not involved in the company, but he was a man behind the scene. So he's an alter ego. Like Najib is the alter ego of MDB, it became necessary to identify all assets within jurisdiction owned by Lorraine. The entered pillar order granted by another judge in aid of the bereavement injunction was necessary as it was aid to justice as far as the respondent bank was concerned. And this was a appropriate case to grant the bereavement injunction together with the entered pillar order after the corporate veil was lifted. You see? So there is a civil procedure in Malaysia, in USA, DOJ forfeiture. Now we know Jolo and other people took those monies, bought assets and diverted it and hide it under various companies. Supreme Court allowed Bank Bumi to apply for a bereavement injunction and an entered pillar order. These are two legal nuclear weapons. A bereavement injunction can be used, alright, to prevent any dealings in any assets throughout the whole world. And the entered pillar order is the order to demand Jolo and all the culprits, right, to deliver documentation, alright, to aid in the investigation. Yet, despite Section 214, 249, 250, 253, 254. No civil action taken to recover the assets, except DOJ. Alright, except DOJ. Why has not, if Najib is innocent, if the government was not complicit, Mr. Finance, why don't the government, like Bank Bumi, went after Lorraine Osman with a bereavement injunction, entered bill order, freeze the assets, get it back to Malaysia? This is a BMF case. And I told you in my remarks previously, there was a recommendation was criminal action and civil action to recover the assets. You see? Why am I so angry? When all these things must be before the country. We're finished talking about the amount stolen. Now we are talking about how to go after the culprits. There is a precedent in the BMF case, Lorraine Osman. Lift the veil of incorporation. Okay. Now, to conclude, once the veil of incorporation is lifted, the man behind the mastermind, whose authority is Najib, and under the Act, he is deemed to have committed offences and also committed offences. He has paid a fine in excess of 2,000 ringgit. You tell me now, members of parliament across the entire political divide, can you allow Najib to remain as Prime Minister? Is it fit? He can't deny he has not committed any offence. He can't deny fine has been paid. If that's so, what are you going to do about it? UMNO, MCA, Gerakan MIC, you have a duty to this country, to the rakyat. This is a way to solve the problem and regain the dignity of Malaysia. Ask your leader to step down. I'm not after his blood, we're not after his blood. Step down, step aside. You're a criminal. He admitted it. Fine was paid. The AG may say, there's no offense on a donation. 6.1 million. But all the other transactions having been revoked, it became unlawful, a crime, but he cannot prosecute. So he says, we impose a fine. And Bank Negara imposed a fine with the consent of the AG, numbskull. So AG cannot deny there's no offense. He can deny the donation. It's a donation, no offense. Some like Saudis. I don't care. Let's focus on those areas where we can prove beyond all doubt, no question asked. You MPs of both sides says the people don't understand, you know. Billions. They can't even understand millions. So intricate, the transactions, offshore loans, tax havens, what have you. Is it that difficult? It's so simple. By our own law, crime has been committed, culprit identified, fine paid, no challenge of the finding against the Attorney General and Zeti, the Governor of Bank Negara. In a way, I have to take AG. In a way, takes a bit of guts. He may not have the guts to prosecute the Prime Minister, but he did the minimum, the barest minimum under the law, to at least save the dignity of the Attorney General Office. And Zeti likewise did the minimum to safeguard the integrity of Bank Negara by giving the minimum punishment. But we are not interested in punishment. What is important, right, is guilt, criminality has been established beyond all doubt. Understand, numbskull, beyond all doubt? He's a criminal. He can't go stand. AG cannot go stand. Okay? AG cannot go stand. Because a fine, an offer of compound, can only be made if an offense has been committed. So, offense committed, fine offered to you, pay the fine or go to court, go to jail. They are rushed to pay the fine. So, can AG deny that? No offense, he cannot. As he can say on a donation, there is a specific law, Foreign Service Act. And we have the Loren Osman situation, civil procedure. Lift the veil of incorporation. This, my dear fellow Malaysians, MPs in Parliament of BN, Pakatan Harapan, I know you're angry with me for criticizing you and whacking you, for your failure to do what's right. I'm the rakyat, I have the right to whack you. For your failure to do your research, for your failure to tell the truth to the country. If you have humility, and you really have the interest of the rakyat, and if you say you are a champion of the rakyat to do justice, uphold the rule of law, then, after my explanation yesterday and today, there's no excuse for you to moralize the entire country to say that this man cannot qualify to be a candidate in this election. Even if legally I'm wrong, I don't think so. Morally cannot. Look at Contracts Act, Section 24. If a contract is morally wrong, with a moral objective, immoral objective, may be legal, there may not be any provision in the penal code to charge them, but if it's morally wrong, Section 24 of the Contracts Act, the law will say that that contract, that act is unlawful, illegal. So morality is the basis. How can we, as Malaysians, I don't care whether from BN, Pakatan Harapan, UMNO, MCA, Gerakan MIC, PKR, DAP, Amanah Bersatu. I'm your rakyat, I'm the rakyat. Don't you dare say I have no right to criticize you. used for election, you call yourself YB in parliament. Then do your job and don't expect the riot to do a job for you. And don't complain why the riot not responding. Why do you don't have the courage? When you don't show the same courage, dedication, discipline to seek truth from facts and present it in the most simple, direct, unvarnished manner. The ugly truth. To my fellow Malaysians, I'm begging you, this is the last chance. Allah gave you and me a free will and free choice. Now that I've given you so stark terms, the minimum you can do, go to MP. Ask them to show you the Financial Services Act 213. If you don't have it, they must buy one from you, let you see. Ask them to explain to them in front of a lawyer. Ask them to get a copy of this authority Esparta against BBMB, 1988, 1 MLJ, 970. 97. 1 MLJ, 1988, 1 MLJ, page 97, Esparta, Silverheart, and 21 others against BBMB. Okay? Says you can lift the veil of incorporation in this fraud, and if the company is used as the vehicle to hide assets and monies. Jolo's been doing that, Rizal has been doing that. Don't you have any shame that we're only waiting for DOJ to recover monies? PAC, wake up lah. Reconvene again. It's not over. For heaven's sake. What else are you waiting for? And to my country, and to my countrymen, I have a very simple philosophy now. I've done my part. I went to jail for the country. I went to jail for you. I went to jail to uphold justice, the rule of law, integrity, honor, and self-respect of our country. For the flag, for king and country. I've done my part. Therefore, I have a right to demand action on them, on MPs, on leaders. I'm not asking you to go to jail to make any sacrifices. I'm asking you to do the barest minimum. Ask now your MPs, your ADOM. Apply the law, criminal and civil. With that, once again, I implore you to surrender completely to the will of Allah, God Almighty. Have absolute faith that He will protect us, defend us, and guide us under all circumstances in the face of all enemies, adversities, and challenges, and ignorance and stupidity. May there be clarity and a proper vision that we will hold the one flag, one national anthem in the name of God, King and country. We will go on that righteous path for victory. With that, I thank you for your attention and I pray for all of you. Thank you.